Dear viewers, today I would like to discuss about res-judicata. The res-judicata, the doctrine of res-judicata has been stated under section 11 of the Code. So, let us come to the point. What is res-judicata? As per section 11 of the Code, the re-adjudicated means pre-trial and final judicial decision of the court of the competent jurisdiction. The expression it is a Latin term and it draws from Roman law, which means one matter already been judged. So, in this connection, if this matter is once adjudicated, cannot be re-adjudicated. If the matter was settled between the parties, cannot be contradicted by anyone. The same subject matter cannot arise between the same parties. If it is found that once the issue has been settled by the court, cannot arise in any stage of future between the same parties or co-parties with the same subject matter. In the word of SPENCER BOWER Res-Judicata means a final judicial decision pronounced by a judicial tribunal having competent jurisdiction over cause or matter in litigation and over the party thereto. This is the way res-judicata is applied either question of law or either question of fact, sometimes both. In according to section 11 of the Code of the Civil Procedure, it has been stated that no court shall try any suit or issue in which the matter directly or substantially in issue in a former suit between the same parties or parties under whom they or any of them claim litigating under the same title in a competent court to try such subsequent suit or the suit in which such issue has been subsequently raised and has been heard and finally decided by such court. It includes the 6 expressions such as expression number 1, the expression of former suit shall denote a suit which has been decided prior to the suit in question whether or not it was issued thereto. This is the explanation number 1. Then explanation number 2. For the purpose of this section, the competence of the court shall be determined irrespective of any provision as to right and appeal from the decision of such court as was set up in the suit. This means there shall be identified of the subject matter in both the two. Explanation number 2. Explanation number 2. For the purpose of this section, the competent scope of work shall be deemed irrespective. Provision as to right and appeal from the decision of such court as is set up in the suit. This means there shall be identified the subject matter in both the suits. The 3. The matter above referred to must in the former suit have been alleged by one party and either denied or admitted expressly or impliedly by the other. Then expression number 4. Any matter which might or ought to have been made of defense or attack in former suit shall be to have been a matter of treaty or substantial issue in such suit. Then expression number 5. Any relief claim in the plaint which is not actually granted by the decree shall form the purpose of this section be deemed to have been revoked. Then explanation number 6. or person litigate provide in respect of public right or of a private right claimed in common for themselves and others or person interested in such right shall for the purpose of this section be deemed to claim another one. Here we are. This is the doctrine of res-judicata under section 11 of the code. The main things of the section is that if any